Good day, folks. We're just syncing our, just syncing both of our lives here. So just, if you don't mind holding tight here, we will get this going. And here we go. Okay, so we're going to be live on YouTube and Facebook tonight. So bear with me as I jump between screens to check comments if you are commenting on the content or any of the story parts that I am bringing forward. Also keep in mind that you are welcome to call in. Now, what is our studio line, folks? It is 604-385-5093. Feel free to call in and talk about the Trump corruption, the crimes, and the presidency. By all means, it's an accountability test tonight that we're going to be looking at. And if you would like to discuss Trump and any of his policies, the administration, the lack of accountability, I would call it, feel free to call in. Again, the phone number is 604-385-5093. You can call in while we're live. If you're watching a rebroadcast of this, you're always welcome to call in and leave a message on the studio voicemail for the next episode where we may air your comments. Keep in mind, folks, that if you do have comments that you don't want to put up in the chat room or to call in live, you're also welcome to send private messages via email to smile, S-M-I-L-E, at propixcanada.com. That's P-R-O-P-I-C-S Canada.com. Also, just a quick announcement and thank you to our program sponsor or the episode sponsor, and that is Carry Movers Limited in Western Canada, your #1 long-distance commercial, residential, and, of course, office movers. You can find Carry Movers online at www.karymovers.com. Thanks for their support of yet another episode of Live Chat with James. As we get started tonight, ladies and gentlemen, we are going to be looking, as I said, at the accountability test, and that's Trump, the law, and, of course, his presidency. What a mess it has become. But first of all, good evening. I am James Cousineau, and this is ProPix TV News, a special report and live chat. Never before in American history has a president been convicted of a felony. Never before has the Supreme Court granted a president sweeping immunity from criminal prosecution for official acts. And never before has the fundamental principle that no one is above the law faced such a profound and direct challenge. Tonight we're going to dissect the years of alleged illegal activity, corruption, and constitutional crises that have brought the United States to this moment. We will examine the evidence, the legal battles, and the far-reaching consequences for the rule of law, the presidency, and the America's place in the world. The central question is not merely about one man, though, of course, but also about the durability of American institutions in the face of unprecedented stress tests. This is the accountability test. The People v. Donald Trump is a legal reckoning. The story begins with a historic chapter in American law. After leaving office in 2021, Donald J. Trump became the target of 4 separate criminal investigations, culminating in indictments across federal and state jurisdictions that charged him with a total of 88 criminal counts. A first for any president. Now, the New York conviction was the Stormy Daniels case. The first case was to reach a verdict, and that was this one. It was in New York State courtroom. On March the 30th, 2023, a grand jury indicted Donald Trump on 34 felony counts of falsifying business records in the first degree. The prosecution, led by District Attorney in Manhattan, Alvin Bragg, argued that the crime was not simply the payment of hush money to an adult film actress, Stormy Daniels, before the 2026 election. Instead, the core felony was an elaborate scheme to cover it up, falsifying invoices, checks, ledger entries as legal expenses to conceal damaging information and unlawful activity from voters just days before they went to the polls. The mugshot of Donald Trump appeared everywhere, and after a 6-week trial on May the 30th, 2024, a jury of 12 New Yorkers found Donald Trump guilty on all 34 counts, making him the first former U.S. president to be convicted of a felony. Following his victory in the 2024 presidential election, he was sentenced on January the 10th, 2025 to an unconditional discharge, a conviction on his record, but no jail time, fines, or probation. Now, let's talk about the secrets at Mar-a-Lago and the classified documents case. Now, the second indictment was federal. It was unsealed in Florida in June of 2023, and it charges Trump with 40 criminal counts, including 32 counts of willful retention of national defense information under the Espionage Act, as well as conspiracy to obstruct justice. The allegations were grave that after leaving the White House, Trump had illegally kept hundreds of classified documents at his Mar-a-Lago estate, including top secret materials related to nuclear programs and military vulnerabilities, and then conspired with aides to hide them from federal investigators. Now, this case would never reach a jury. On July the 15th, 2024, Judge Eileen Cannon, a Trump appointee, dismissed the entire case. Her ruling was not based on the evidence, but on a procedural argument that the appointment of special counsel, Jack Smith, was unconstitutional. While the Justice Department initially appealed it, it abandoned that appeal following Trump's 2024 election victory, citing its long-standing policy not to prosecute a sitting president. Now, the attack on democracy in the federal election obstruction case, and that was the third indictment, also brought by Special Counsel Smith, struck at the heart of American democracy. On August the 1st, 2023, a federal grand jury in Washington, D.C. indicted Trump on 4 counts related to his efforts to overturn the 2020 presidential election. The charges included conspiracy to defraud the United States and obstruction of an official proceeding, directly linking his actions to the violent attack on the U.S. Capitol on January the 6th, 2021. Sorry, folks, just checking the message boards as I got to jump back and forth. So by all means, if you have comments, throw them up on the comment board. Also, don't forget that you can call in live if you wish to area code 604-385-5093. Join us in the conversation. You're more than welcome to call in. Now, this case, however, was quickly frozen. Trump's lawyers claimed he had absolute presidential immunity from prosecution for any action taken while in office. The argument went all the way to the Supreme Court. They paused the case for months. After the court issued a complex ruling granting immunity for official acts, the case was sent back to the lower courts. But before any further proceedings could take place, the 2024 election intervened. On November 25th, 2024, citing the same DOJ policy, Jack Smith moved to dismiss the case. Obviously, a lot of backroom deals going on. Now, the Georgia racketeering case, the state election interference case as it was. The final indictment came from Fulton County, Georgia on August the 14th, 2023. Now, this was using the state's powerful racketeering, influenced, and corrupt organizations, or RICO Act. Now, this is, of course, brought by District Attorney Fani Willis, charged Trump and 18 co-conspirators with operating a criminal enterprise to willfully and unlawfully overturn Georgia's 2020 election results. Trump himself faced 13 counts, later reduced to 8, including the central RICO charge. Like the federal cases, though, the Georgia prosecution has been marred in procedural delays. The case was paused for months while the appeals court considered a motion to disqualify Willis over a personal relationship with another prosecutor on the case. The court ultimately removed her from the case in December of 2024. Now, with Trump back in the White House, the case faces a new unresolved constitutional hurdle. And that is whether or not a sitting president can be prosecuted on state-level criminal charges at all. Again, bringing the courts to a halt on that one. Now, when you look at the landscape, a clear pattern emerges. Outside of New York, the primary legal strategy was not to prove innocence or contest the facts of allegations. The approach was to use every available procedural tool, appeals on special counsel's authority, on presidential immunity, on the prosecutor's conduct, to delay the proceedings. The goal was not vindication in a courtroom, but survival until the 2024 election. It was a bet that a political victory could render the legal challenges moot. In the two federal cases, that paid off. The Justice Department's own policies became the ultimate escape hatch, allowing the cases to be dismissed without a single piece of evidence ever being presented to a jury. This transformed the legal battles into a political race against time, where the calendar became more important than the evidence. It was essentially a shield of immunity and a sword of liability. The dismissal of the federal election case was made possible by one of the most consequential Supreme Court decisions in modern history. The case, Trump v. United States, fundamentally reshaped the power of the American presidency. The Supreme Court made landmark rulings. On July the 1st, 2024, the court ruled in a 6-3 decision that the former presidents enjoy a powerful, multi-layered immunity from criminal prosecution. It established 3 distinct categories of presidential conduct. First, for actions that fall within a president's core constitutional powers, such as commanding the military, issuing pardons, or directing the Department of Justice, the court granted absolute immunity. They cannot be prosecuted for these acts, period. Second, for other official acts that fall within the outer perimeter of their duties, presidents have presumptive immunity. A prosecutor could theoretically bring charges, but would first have to prove that a conviction would pose no danger of interfering with the executive branch's authority. And that is a very high bar to clear. Now, third, for purely unofficial or private acts, the court ruled there is no immunity. But the most stunning part of the ruling was this: the court explicitly held that a president's motives cannot be examined when determining if an act was official. This means a president could order the Justice Department to prosecute a political rival, which, imagine that, for entirely baseless and corrupt reasons. But because directing the DOJ is a core power, the act itself is immune from prosecution. Now, the decision was met with a firestorm of criticism. Justice Sonia Sotomayor, in her dissent, called it a one-way ratchet that would reshape the institution of the presidency and risk permitting criminal conduct. Legal experts warned it was a manual for law-breaking presidents, effectively placing the president above the law for a vast swath of potential crimes. And I think Donald Trump is going to prove every one of them. I think he's demonstrating all of these crimes that he's going to get away with. Now, the subordinate's dilemma. There's no immunity down the chain of command. But here it is, the critical distinction. While the Supreme Court shielded the president, it offered no such protection to the administration officials who must carry out his orders. The legal principle is clear. An illegal directive does not become legal just because it was issued by a president who is now immune from prosecution. Under the current precedent, any official, from a cabinet secretary down to a civil servant, who knowingly enforces an unconstitutional or illegal executive order could be criminally prosecuted, assuming the elements of the underlying crime are met. I think that covers a lot of the Trump administration. I think that they don't realize how much liability they are carrying. Now consider a concrete example. The Constitution gives Congress the power of the purse. A president cannot unilaterally refuse to spend money that Congress has appropriated, although we've seen him do it. An executive order to unlawfully impound those funds would place agency officials in an impossible position. If they obey the president's illegal order, they risk administrative discipline. They could face suspension without pay and even criminal penalties under a law called the Anti-Deficiency Act. If they refuse the order to uphold the law, they risk being fired by the president. This dilemma extends to the military. The law of military obedience requires service members to obey lawful orders, but it is also imposing a legal duty to disobey manifestly or patently illegal ones. An order to intentionally target civilians, for example, is a war crime. Let's take a look at what's happening in international waters off the coast of Venezuela. A soldier who carries out such an order cannot use the defense that they were just following orders. The legal liability rests with them. This creates a perilous new dynamic at the heart of the executive branch. The Supreme Court's decision grants the president a shield for his own actions while leaving his subordinates exposed. This structure transforms every controversial or legally dubious directive into an implicit loyalty test. An official is no longer just deciding whether to implement a policy. They are forced into a personal calculation, weighing their own potential criminal liability against their allegiance to the president. An official who prioritizes their oath to the Constitution might be forced to resign or refuse an order. An official whose primary loyalty is to the person of the president might carry out this order, accepting the personal legal risk. The system incentivizes a president to surround himself only with the latter, potentially purging the executive branch of those who adhere to the rule of law in favor of those willing to risk prosecution. We are seeing clear images of this. It's a dynamic that could fundamentally alter the nature of public service, replacing constitutional duty with personal fealty and eroding the integrity of our governing institutions from the top down. As we look at this, it's, a very complex issue. And as we move on to the next segment, let's first take a quick break to recognize, again, this episode's sponsor. It's Carry Movers. Yes, this in-depth report is brought to you by Carry Movers Limited. Whether you're moving an office or a home, trust the experienced professionals at Carry Movers. Find out more at www.carrymovers.com. Serving Western Canada for several decades in the residential, commercial, and office relocations throughout Western Canada for long-distance relocations. And of course, serving Metro Vancouver and the Fraser Valley for all local and long-distance moves that you may have. Now, let's get back to the business of power, and that's the emoluments and enrichment. The framers of the Constitution in the U.S. were deeply concerned about the potential for foreign corruption to infect the new republic. To guard against it, they embedded a specific anti-corruption tool directly into the text, and that was the Foreign Emoluments Clause. The Constitution's Anti-Corruption Clause, found in Article 1, Section 9, the clause prohibits any person holding office of profit or trust from accepting any payment, gift, or benefit, an emolument, from a foreign state without the consent of Congress. The goal was simple: to prevent foreign governments from using financial incentives to gain influence over over American officials. For over 200 years, this clause was rarely tested. Presidents from both parties routinely divested from their business assets or placed them in a blind trust to avoid even the appearance of a conflict of interest. Donald Trump broke with that tradition. By refusing to divest from his global real estate and branding empire, critics argued he was in violation of the Emoluments Clause from the moment he took the oath of office. The allegations were numerous and specific. Foreign government officials buying up entire floors of rooms at the Trump International Hotel in Washington, D.C. The state-owned Commercial Bank of China paying rent as a tenant in Trump Tower. Foreign diplomats hosting lavish events at Trump properties to curry favor with the administration. Each of these transactions represented a potential stream of revenue from a foreign government flowing directly into the president's private businesses. Multiple lawsuits were filed by ethics watchdogs, state attorneys general, and members of Congress to challenge these arrangements. But they all met the same fate. After years of litigation, the cases were ultimately dismissed as moot because Trump left office in 2021. Without any court ever ruling on the merits of the claim, this outcome exposed a critical flaw in constitutional enforcement: the inability to hold a sitting president accountable in real time for these potential violations. There's a pattern of self-dealing here. The emoluments issue was part of a broader pattern in which the lines between the Trump campaign and the Trump organization and the U.S. government became almost indistinguishable. During his first run at the presidency, Trump's own businesses received at least $8.5 million from his political fundraising committees. These were payments for rent at Trump Tower, for venue use at his golf clubs, and for other services. While campaign finance law allows candidates to spend money at their own businesses, provided they pay a fair market rate. The practice creates a clear and troubling appearance of self-dealing, where donations from political sponsors are funneled directly back into the candidate's personal pocket. This pattern extended to the highest levels of government. And when I bring that up, we're talking about the government celebration. Trump's 2017 presidential inauguration committee raised a record-breaking sum of money, but it soon came under investigation by federal prosecutors in New York. They issued subpoenas seeking documents related to the committee's spending, including large payments made to the Trump family's own hotel in Washington, and whether any of its funds came from illegal foreign contributions. When viewed together, these are not isolated incidents. A traditional president divests to avoid the appearance of conflict. Here, foreign governments seeking influence had a direct financial path, patronized the president's businesses. At the same time, political supporters' money was used to pay the president's own companies. This suggests a fundamental reframing of the office itself, not just as a seat of public service, but as the ultimate asset in global business portfolio. The presidency became a powerful tool for generating revenue, enhancing brand value, and creating a system where holding public officials was leveraged for direct and indirect private financial gain. Continuing on in his second term. Now let's take a look at the MAGA money machine. Is it a movement or a grift? You know what I think. While the Trump organization profited from the presidency, a parallel financial operation was underway, a massive fundraising apparatus that blurred the lines between a political movement and a personal slush fund. You've got to trace the flow of money. The sums of money are staggering. Trump-affiliated political action committees, or PACs, like the Leadership PAC, Save America, and the Super PAC, MAGA Inc., raised hundreds of millions of dollars. A significant portion of this came after the 2020 election, when the campaign solicited donations for a so-called official election defense fund. Supporters were told that their money would be used to fight election fraud. The campaign raised $250 million on that premise, but according to the House committee that investigated the January 6th attack, much of that money simply enriched Trump's new political war chest. The fundraising tactics themselves became notorious. The campaign sent out a constant barrage of bizarre, emotionally charged emails, and still does, I might add. Often using aggressive and misleading rhetoric, it also pioneered the use of pre-checked boxes on its donation website, which automatically signed up unwitting one-time donors for recurring weekly or monthly payments. The practice led to a flood of fraud complaints from Trump's own small dollar supporters, some of whom saw their bank accounts drained by withdrawals they never authorized. Now, let's take a look at paying legal bills. Excuse me, folks. Well, just a sec. Take a quick sip here, and we'll get back. I love my coffee. So where did all this money go? A huge portion went to pay Donald Trump's personal legal bills. And this is where a critical loophole in campaign finance law comes into play. While a candidate's official campaign committee is legally barred from paying for personal expenses, the Federal Election Commission has failed to apply that same personal use prohibition to leadership PACs like Save America. Excuse me. Now, this loophole became a financial lifeline. Since 2020, Trump's network of political groups has spent over $131 million on legal fees. This donor money has been used to pay for lawyers in nearly all of his legal battles, from the cases related to overturning the election to the civil fraud probe into his private business practices in New York. These are expenses that for any other citizen would be a personal responsibility. Here they were covered by political donors who gave money to save America. The system reveals a pervasive incentive structure. It's perverse. Now, Donald Trump's legal and political controversies are not financial liabilities. They have become his most valuable fundraising assets. Each indictment, investigation, and legal setback is immediately packaged into a narrative of political persecution, a witch hunt, which is then used to solicit urgent donations from a loyal base. Fundraising has been shown to spike immediately following major legal events. That money is then funneled through PACs that, because of the legal loopholes, can pay for the very legal defense that prompted the fundraising in the first place. It's a self-perpetuating cycle. Legal trouble creates a victimhood narrative. That narrative drives fundraising, and that fundraising pays the legal bills. The political base is not just funding a campaign, it's underwriting the personal legal defense of the candidate, transforming political support into a financial shield against accountability. Big deal, right? It is when you think about how much of that money could be used in other ways, and why they are using these legal loopholes and dragging out cases. He's using it as a money machine to grift more money out of his supporters. Let's again take a look at our sponsor tonight. ProPix TV News is proud to partner with Carry Movers Limited, your trusted partner when it comes to commercial and long-distance moving. Visit them at carrymovers.com. That's K-A-R-Y movers.com. Let's get back to our report now. Let's take a look at the instruments of power. Tariffs, kill orders, and gaslighting. Sounds pretty commonplace in the Trump factory, or the Trump administration, as you may want to call it. But beyond the legal battles and the financial dealings, the Trump administration has employed a governing style that often relies on asserting a narrative at odds with objective facts. We're going to examine three key examples: tariffs, economic claims, and the use of military force. It's a lie, the tariffs. Who's really paying? The central promise of the America First agenda has been the use of tariffs to protect the American industry. Throughout his campaigns and presidency, Donald Trump has repeatedly and forcefully claimed that the foreign countries like China pay these tariffs. This is fundamentally false. A tariff is a tax. It is paid to the U.S. government by the American company that imports the goods, whether it's Walmart importing electronics or a home builder importing lumber. That cost is then absorbed by the company, which cuts into their profits, or more commonly is passed on to the American business and consumers in the form of higher prices. It's amazing that people still believe that foreign countries are paying these damn tariffs. The economic data is clear. Multiple studies have found that U.S. firms and consumers have borne nearly the entire burden of the tariffs. This has resulted in a net loss to the U.S. economy, higher prices on everything from washing machines to construction materials, and has been estimated to have cost hundreds of thousands of American jobs. The money that comes in from tariffs does not come from foreign governments, it comes from the pockets of Americans. Trump has been quoted as claiming at times that the $17 trillion fantasy that he lives in is real. It's a case study, clearly, of gaslighting. In September 2025, President Trump made a stunning claim. In just 8 months, his administration had secured $17 trillion in new foreign investment to the United States and trillions of dollars in tariff funds. To put that number in context, the entire projected economic output, the gross domestic product of the United States over the next 5 years, is about $169 trillion. Trump claims amounted to 10% of the entire U.S. economy materializing in just 8 months. The number is an economic impossibility. Even the administration's own White House website listed a far lower figure of $8.8 trillion, and that number in itself was padded with investment commitments made during the previous administration. Expert analysts from the Peterson Institute for International Economics concluded that the actual increase in new investment commitments was in the hundreds of billions of dollars, not even close to $1 trillion. The $17 trillion figure was a fantasy constructed from disputed numbers, vague intentions from foreign companies, and double counting of old announcements. It's false. Plain and simple, false. Lies. Trying to manipulate the Trump supporters into thinking that the economy is all, sugar plums and rainbows. Now let's shift gears and take a look at In Order to Kill, the Caribbean strikes. In the fall of 2025, the Trump administration announced a new front in the war on drugs, and that was U.S. military forces conducting a series of lethal strikes in the Caribbean Sea, killing more than 20 people on boats, alleged to be carrying narcotics. The administration, including the Secretary of Defense, Pete Hegseth, defended the strikes as necessary actions against narco-terrorists. This action was widely condemned by legal experts as a dangerous and illegal use of military power. Under the U.S. Constitution, only Congress has the power to declare war. The administration bypassed Congress entirely. Furthermore, simply designating a drug cartel as a foreign terrorist organization does not, under U.S. or international law, automatically authorize the use of lethal military force against its members, especially in international waters. This was not an act of war or self-defense. It was an extrajudicial killing carried out without due process. This illegal order also places the American service members who carried it out in extreme legal jeopardy. An extrajudicial killing is murder. Under the Uniform Code of Military Justice, every person in the chain of command who planned, ordered, or executed the strike could be prosecuted for murder, conspiracy, or aiding and abetting. The president's potential immunity does not extend to the soldiers who pulled the trigger. These three examples, the tariff lie, the $17 trillion fantasy, and the kill orders, are not just distinct policy failures. These represent a unified government strategy that relies on creating and enforcing an alternate reality. The administration asserts a falsehood as fact, that foreigners pay tariffs. It manufactures an unverifiable success story, the $17 trillion investment. And it redefines legal terms, labeling drug traffickers as terrorists to justify unilateral military action. This strategy aims to make objective, fact-based criticism impossible. It erodes public trust in the media, in economic experts, and in the rule of law itself, forcing all debate onto the administration's own distorted terms. It is the weaponization of misinformation as a government tool and a governance tool. Now let's take a look at the America First, the global security. Yeah, global security last in his, in Trump's opinion. But the effects of this governing philosophy extend far beyond the borders of America, reshaping global alliances and creating a new, more volatile world order. It's straining alliances. It's emboldening adversaries. The America First foreign policy is built on transactional worldview. It rejects decades of multilateral cooperation and views traditional allies like the members of NATO or the European Union not as partners in a shared security arrangement, but as economic competitors or freeloading dependents who are taking advantage of the United States. Trump has openly questioned the mutual defense commitment at the heart of NATO and is engaged in trade wars with allies like us here in Canada and over in the EU. The international response has been one of alarm and adaptation. Allied leaders have learned to respond with a mix of public flattery and private contingency planning. They seek face-to-face meetings and come bearing flashy deliverables that the president can announce as wins, all the while quietly hedging their bets by seeking alternative security and trade partnerships, recognizing the United States as an increasingly unpredictable and unreliable leader. Now, where are we at in terms of seeding the global stage? This approach has led to a dramatic U.S. withdrawal from global leadership. The Trump administration has pulled the United States out of key international agreements, including the Paris Climate Accord, the Iran nuclear deal, and has withdrawn funding and support from organizations like the World Health Organization. This has created a significant power vacuum on the world stage. That vacuum is being aggressively and strategically filled by China. Beijing is not just gaining influence, it is actively reshaping the global order to suit its own interests. Through its Belt and Road Initiative, it's become the primary development partner for much of the global south. Through its Global Security Initiative, it offers an alternative to U.S. military alliances. And by dominating supply chains for emerging technologies like artificial intelligence and green energy, China is positioning itself to write the international rules and standards for the 21st century economy. So it brings the question, what should the international community do? This presents a profound dilemma for the rest of the world. How to maintain global security and address collective challenges like climate change, pandemics, and nuclear proliferation, when the world's most powerful nation is actively undermining the very institutions designed to manage them. There's no easy answers. The analysis suggests that other democratic powers must accelerate their efforts to strengthen their own alliances. And those need to be independent of Washington. They need and must invest more in multilateral institutions and prepare for what experts call a multiplex world order, one in which American leadership is no longer a given, and one that is more fragmented, multipolar system that is the new reality. The American First policy was intended to reassert American dominance by shedding what were seen as international burdens. The evidence suggests it's having a precisely opposite effect. By creating a vacuum, forcing allies to become more self-reliant and emboldening adversaries, it is accelerating the transaction to a post-American global order. The policy is not preserving American power, it's actually hastening its relative decline by dismantling the very alliance system that amplified U.S. influence over the past 75 years. So where does that leave us? Well, the verdict of history. We have covered a great deal of ground tonight. A historic criminal conviction of a former president and re-elected president that is back in for a second term, with a pause in between. A radical redefinition of presidential immunity by the Supreme Court. A persistent pattern of financial self-dealing that blurred the lines between public office and private profit. A governance style that relies on overriding objective reality and foreign policy that has been basically destabilizing the global order. The local cases are, for the most part, over. And those in terms of the legal matters, the civil cases. The political battles will undoubtedly continue, but the verdict of history is yet to be written. The events we have examined tonight have tested the core tenets of American democracy, accountability, and the rule of law, as well as the peaceful transfer of power. The ultimate question is not what this means for one man, but what it means for the future of the Republic, whether its institutions are strong enough to endure. Some very big questions. Let me know what you think down below in the comments section. Don't forget that you can always call in and leave a message on the studio voicemail for airing on future episodes. You can leave that voicemail and call in the studio live during live feeds at 604-385-5093. Once again, folks, you've been watching Live Chat, a special edition with James here at the ProPick Studios in Vancouver, British Columbia. We'd also like to thank our sponsor again, Carry Movers, for making this special report possible. For professional moving services, you can count on visit carrymovers.com. That's www.carrymovers.com. I am James Kuzno for ProPix TV News and True Crime and Justice TV News. Good night, everyone. Take care. Don't forget to like, follow, and subscribe.